Big story breaking tonight, just moments ago, out of Alabama, as the top judge in that state takes a dramatic stand against the U.S. Supreme Court decision legalizing same-sex marriage. Judge Roy Moore, the Chief Justice of the Alabama State Supreme Court, ordering state officials today not to issue marriage licenses to same-sex couples. Some officials are following the order, others are outright ignoring it. Joining us now, Brian Brown, who is president of the National Organization of Marriage. Brian, thank you for being here. So how can the judge do this in the face of the Supreme Court decision saying gay marriage is legal, period, in all states?
Well, it goes to your understanding of whether you believe that the Supreme Court has the right to dictate to the rest of the country key questions. Abraham Lincoln, when faced with a Supreme Court that issued the infamous Dred Scott decision, said that it did not. The Supreme Court is not our legislature. It is not every branch of government. And when the court issues an opinion, as it did in Obergefell, which goes against all precedent, which goes against all logic, which even Justice Roberts, Justice Scalia, Justice Thomas in the dissent said that this is not the Constitution, then it's incumbent upon legislators, other elected officials, state government officials to not just kowtow to the court, or else we don't have a democracy anymore.
So the Supreme Court has the final say on what the law is. That was established long ago in Marbury versus Madison. But here's my question to you. This is what Governor Huckabee said would and should happen. This is what he was pushing for, saying, to you, U.S. Supreme Court, you don't get the final say. I don't care about Marbury versus Madison. And he encouraged state officials to do exactly this. How does this unfold? I mean, aren't we going to have chaos now if states are individually allowed to decide which Supreme Court decisions they're going to comply with and which they're not?
Well, I think you're misreading Marbury versus Madison. Again, you're essentially saying that Abraham Lincoln was wrong. Look, we've had horrible Supreme Court decisions that were not constitutional. In Buck v. Bell, we had the Supreme Court say it was okay for governments.
You go back to the legislature and you ask them to pass a law.
That's not what happened. In the Fugitive Slave Act, Wisconsin and other states simply did not comply. You do get to a point where if tomorrow the Supreme Court said Congress no longer has the right to enact laws, everyone would look up and say, no, we're not going to obey the Supreme Court. So, of course, in the general course of law, the Supreme Court, when dealing with litigants, makes a decision that's based on precedent. People give it respect. But if the Supreme Court makes a decision that is so outside the bounds of established constitutional law, established precedent, like Dred Scott, like Buck v. Bell, like Obergefell, then there has to be resistance or you don't have democracy anymore.
Interesting take on it. Brian, thank you for being here. We appreciate it.